self-defense cases, and is a pretty good rendition of it. It references, for example, Thompson, which is State versus Thompson 552, Southern 2nd 24. That's an aggravated battery case where he tried to stop a fight, was attacked, defendant backed up, brandished a gun, aggressor continued to approach, defendant shot him. And that was where the court reversed the conviction on that, suggesting that the judgment of acquittal should have been granted. The Hernandez-Ramos case at 496 Southern 2nd 837, again cited in Jenkins, gives some good insight into a somewhat similar fact scenario. In that case, evidence was there that the defendant took some effort to ward off the attack or end it without violence. The state's witnesses in that case uniformly identified the victim as the aggressor. We have one eyewitness in this case, John Good, I think, would present a scenario very similar to that presented by the state witnesses in Hernandez-Ramos, and that is that we know, and it is completely uncontroverted, that Mr. Martin was the aggressor in that he had mounted Mr. Zimmerman, refused the suggestion by Mr. Good to stop doing what he was doing, and continued the attack. Similar to Hernandez-Ramos, the state's witnesses in that case suggested that the victim in the case was the aggressor. And again, that case similarly was suggested that judgment of acquittal should have been granted. Now, that is looking at the issue of the circumstantial evidence and the direct evidence would exist and whether or not my client has presented a prima facie case of self-defense. I think that if you reach that alone, then the case should simply be dismissed presently at judgment of acquittal. As I said a moment ago, I can't say, Judge, can I stop and let you rule, and I'll start over if you don't. So I have to continue as though you're not following my first track, and I'll go to my second track. And the second track is whether or not, should the court not agree that a prima facie case of self-defense has been proven, and that to the extent that circumstantial evidence is being considered by this court as presented by the state, if you decide that that does in fact exclude any possibility of my client, any hypothesis of my client's innocence. If for some reason I've lost those two arguments, which I think the evidence supports that we should win. If we don't, then you have to look at whether or not this case should still move forward on a second-degree murder charge as to the issue of ill will and hatred. So let's talk for a moment about what ill will and hatred is and what it's not. In Light versus State, 841 Southern 2nd, 623, a second DCA case, that was a mosh pit case. Mr. Light didn't like the fact that the eventual victim fell back into him and may have hit him in a sensitive area of his body. So Mr. Light decided to pick him up in a wrestler move, hang him over his head, and smash him to the ground, crushing the left side of his head, I think it was, on the cement. He sort of got up, made it outside, and died. And the court ruled that that behavior, though extremely reckless behavior, to simply get upset at somebody, pick him up over your head, and smash him onto cement, is not ill will or hatred, and would not sustain a second-degree murder conviction because you can't infer any malice. I don't exactly know how you can infer malice from picking somebody up over their head and smashing them onto cement. But if we were to compare that law, which is now the law in Florida, to this case, I would suggest that there is absolutely no evidence to support the contention that Mrs. Zimmerman acted in ill will, spite, or hatred. If you can get past the expletives, and you get past the fact that he seemed to be particularly interested in his community, and that may have been why he focused on Mr. Martin as a suspicious person, looking, unfortunately, similar to what we now know we have in evidence of Emmanuel Burgess, who was his one-person crime spree through Retreat View Circle, who got 5 years in prison for his bevy of burglaries in the area. The court may recall that you were the sentencing judge in that case when he came before you about a year and a half ago. So yeah, an unfortunate circumstance, but that doesn't allow the outrageously over response by Mr. Martin. But sticking to the ill will and hatred argument, basically in the Light case, it was just not ill will because the courts looked to 2 other cases for the instruction on ill will, spite, and hatred. That being Williams versus State at 764 Southern 2nd, 177, another second DCA case, and McDaniel versus State, 620 Southern 2nd, 1308, a fourth DCA case, to begin the analysis that even extremely reckless behavior itself would be insufficient for you to infer any malice that would suggest second degree. I guess in this case, had Trayvon Martin pushed my client, as happened in the Light case when he actually hit him in the genitals, had Trayvon Martin pushed my client and then my client just reeled back, took out his gun and shot him, under Light, I'm not certain that would have been ill will, malice, and hatred, because the other overriding necessity in an ill will and spite and hatred case, and I know the court is aware, is though second-degree murder for ill will, spite, and hatred, not exclusively, because they'll never say never, but almost always the people have to know each other. Because the ill will, the spite, the hatred cannot be momentary, it cannot be instantaneous. All of the cases that talk about ill will, spite, and hatred talk about in 99% of the cases, and that's my percentage, not the case laws, but in the overwhelming majority, it only occurs where that ill will, spite, and hatred has been something that has grown over time. The husband and the wife with the affair, the neighbors fighting over the fence, things like that, so that we can presume that there is ill will, spite, and hatred by previous acts against the two. And it cannot be presumed. It has to be by direct evidence that there was this previous animosity that would suggest the growth or therefore existence of ill will, spite, and hatred. Similarly, there are 2 other cases that at first I didn't think that they were worth mentioning, except as I thought more about them, they were as the issue of ill will, spite, and hatred, and that's State versus Ellison at 561, Southern 2nd, 576, the Florida Supreme Court in 1991. And I'm sorry, Your Honor, and that's Sigler, S-I-G-L-E-R, 805 Southern 2nd, 32. I mentioned those 2 cases for this reason. Those were the high-speed chase cases, factually significantly different from this case, but interesting because in both of those cases, the defendant, one had just escaped from prison, another one had stolen a car, I believe, were high-speed chases, 80, 90 miles an hour, running through intersections, running over curbs, running through toll booths, and just acting about as outrageously as you could act while in a vehicle. And in both of those cases, the courts said that even when you run into somebody and kill them, that's not ill will, spite, and hatred. There's no, in effect, transferred intent from when you act as outrageously negligent as you might act to steal a car and do 80 or 90 miles an hour through a crowded area, running people out of the way and finally killing somebody. That's not ill will, spite, or hatred. So I mentioned those for that purpose. Another case, State versus Ellison, Ellison, 561 Southern 2nd, 576. I'm sorry, that was one of the two that I just mentioned to you, Your Honor. I apologize for that. But that was one of the two cases where, again, in that case, the high-speed chase was not suggested to be ill will, spite, or hatred. Dorsey versus State, 74 Southern 3rd, 521, a fourth DCA case, just a couple of years ago, 2011. In that case, the defendant had a gun. The facts support that he actually went and got the gun to arm himself after having an argument with two victims. Then they came to the car, further attacked him. One guy punched him in the face, and after having armed himself voluntarily in anticipation of continued altercation with these guys, which is the facts of the case, he got hit in the face, took out the gun, shot him, killed both of them, and the fourth DCA said, in that circumstance, where you went and got a gun and came back, no ill will, no hatred, no second degree. An impulsive overreaction to an attack or injury is in itself insufficient to prove ill will, hatred, spite, or evil intent. They were at a keg party and people were getting drunk and they were hassling him. Okay. Bellamy is another case that I presented to the court, 977 Southern 2nd, 682, DCA, second DCA case out of 2008. This was a fight that lasted a couple of minutes, basically a bar fight where they went back and forth. And to the extent of the client, in that case Bellamy's, responsibility in that regard, even though there was no evidence that the victim of the final stabbing by Mr. Bellamy wasn't even known to have caused his own death. So he was, in effect, what was thought by the court to be an innocent bystander, and that Bellamy may have just reached out and decided to start stabbing people, including this guy. There was no ill will or hatred found in that case either. And again, they mention in that case particularly, and also cite a number of cases standing for the proposition that you really, ill will and hatred almost always and only comes from people who know each other before the event begins, because it is almost impossible for that ill will and hatred to grow so quickly in the middle of an affray or a fight or an altercation, quite honestly, such as we have here. Wiley versus State, 60 Southern 3rd, 588. Interesting case because in that case, there was a fight and Wiley decided to take out his gun and smack it against the eventual victim. So it was a deadly weapon, but he didn't use it as a gun, but he used it as a hammer. As it hit him, it went off and killed him. And again, in that case, even though he decided to arm himself with a deadly weapon, decided to do it the way he did, since the intent was not there and there was no ill will and hatred, presumably it would have been found if he stood 5 feet away and shot him. They said that the action and the way it occurred suggests a lack of ill will, hatred sufficient for second-degree murder. So it's a complicated case on judgment of acquittal, I think, in a number of ways, and that is that in a self-defense case, the case law, Walker and others, Woods and others, are quite clear that even at judgment of acquittal stage,